Hi, folks. Welcome to Crisco's Corner. Unfiltered commentary. And not your truth, the real truth. Please like, share, and subscribe. And as always, thank you for your support. Hi, folks. Welcome back. From timcast.com. Supreme Court Justice Kagan. Abortion is part of the fabric of the women's place in this country. That's a little hyperbolic. That's fabric of. It's woven in. And it shows, of course, a ultrasound. This is about the Mississippi law that's being challenged and made it to the Supreme Court, and I'm surprised that it did, and glad as well. Supreme Court Justice Elena Kagan argued that abortion is part of the fabric of women's place in this country. To defend Roe v. Wade, as SCOTUS is hearing the Dobbs v. Jackson Women's Health Organization case. Again, I'm going to say this. I think Roe v. Wade was flawed. It is not a constitutional right to have an abortion. That being said, it's not mean that abortions are unlawful or can't be done. It's never said that ever. The fact of the matter is, anybody that's even a student or just as a hobbyist studies the Constitution and its powers and its limitations knows that the Constitution does not have that authority. It is not a constitutional right. Not like the Second Amendment, the right to bear arms, which they infringe on all the time. Free speech as well, I might add. As Dave Chappelle says, the Second Amendment is second just in case the first one doesn't work out. There is no constitutional right doesn't mean you can't have one. There's no constitutional right to have a driver's license either. But yet you can still get one. And that's all administered by the states. The states are elected by the people in that state to make laws that govern over those people in that state, whether you reside there or passing through there. That's the way it's always been. This makes it a national law. And that was the problem from the beginning. The case they are hearing centers on the 2018 Mississippi law banning most abortions after 15 weeks of pregnancy. That's almost 4 months, guys. If you don't know you're pregnant by 4 months and make up the decision, there's something wrong with you. The law does have exemptions carved out for severe fetal abnormalities or medical emergencies. Mississippi's law had been blocked by the lower courts. On Wednesday, SCOTUS heard approximately 90 minutes of oral arguments for the case, which may be the most direct challenge to Roe v. Wade since its adoption. It's a challenge against Roe v. Wade, not a challenge against abortions. And I wish the mainstream media, the bulk of them, and all the social media monsters would stop lying. The court is currently 6-3 majority for conservatives. Well, more like 5.5, 3.5, but I digress. All of whom appear to be open to challenging the court's previous determination that abortion is legal until a fetus becomes viable, which is very difficult to ascertain. The liberal judges argued it was wrong to overturn a long-standing decision, but Justice Kavanaugh countered that previous decisions were overruled to end segregation and allow gay marriage. That's true. Remember the Dred Scott case? Where, I don't know the person's name. He owned Dred Scott. Dred Scott was a slave, and he was brought up north in a free, non-slave state before the Civil War and spent a lot of time in that state. And said, after I spent X amount of time in this state, I am now free. I went to the Supreme Court, and Supreme Court ruled technically your property, so you cannot be free. And there was a huge firestorm over it, as there should have been. Mississippi's ban on abortion 2 months before viability is flatly unconstitutional under decades precedent. And that's the catch. What's viability when? Center for Reproductive Rights Senior Director Julie Riddleman said during oral arguments, 2 generations now relied on this right, and 1 out of every 4 women makes a decision to end in pregnancy. Little side tidbit, I believe African Americans have a 17% of the U.S. population, but yet they have 50% of the abortions in the United States, and Planned Parenthood and other organizations like that purposely open their facilities and have abortion services in very low-income, heavy minority areas. Sounds like eugenics to me, but I digress. Justice Amy Coney Barrett responded by asking Riddleman, why do women take advantage of safe haven laws? Why don't they? When they can drop off babies at locations such as fire departments without risk facing any penalties, or just give it up to the state, the county, and the baby will put out for adoption or go to Child Protective Services. We don't just focus on the burdens of parenting. Instead, pregnancy is unique and, in fact, has impacted all of their lives and their ability to care for other children, other family members, and their ability to work, Riddleman replied. That's not an answer. It's not an answer at all. Mississippi Solicitor General Scott Stewart, who provided oral arguments in favor of the state's law, pointed to Justice John Marshall Harlan's dissent in Plessy v. Ferguson when the court ruled in favor of racial segregation. In respect of civil rights, all citizens are equal before the law, Harlan said. Stewart argued that these rights must extend to the unborn, and there's the gray legal area. Do the rights of citizens under the Constitution apply to citizens not yet born? All citizens are equal before the law. The state argued the conclusion that abortion is a constitutional right has no basis in text, structure, history, or tradition. And that's the thing that the progressives want to legislate, in this case in the Supreme Court. They want to legislate based on their emotions. Sometimes you don't get your way. The Constitution is the Constitution. And it stood the test of time this long for a reason. Doesn't mean you can't get an abortion. It just means it's not a constitutional right. It's not a constitutional right to vote. It's just amazing to me how they twist and turn this stuff. But it's interesting when they mentioned John Marshall Harlan's dissent in Plessy v. Ferguson when the court ruled in favor of racial segregation. Well, the funny part is those same Democrats back then who were for segregation are the progressive Democrats today that are for segregation. Separate graduations, separate funerals, separate this, separate that, separate fraternities, separate study facilities, safe spaces. The list is endless. Minority-owned businesses, purely black hires, and on and on and on. And in fact, California trying to have their prior civil rights legislation uphold in a referendum. That way they can discriminate against white people, especially males, in corporate world in California. And even the back crap crazy people in California said, no. In respect of civil rights, all citizens are equal before the law. Who represents the unborn, and when are they viable to have rights? Those are really gray legal matters. The one thing that isn't a gray legal matter, and that's the part the progressives just don't grasp in their heads, or they refuse to, and kick and scream and say the world is flat, even though we know it's not, is the fact that it's not a constitutional right. But the states get to administer the procedures and the laws concerning abortion in their individual state. And that's the way it should have been, but it wasn't. In 1972, when I was 16 years old, at the end of 72, I remember when it happened. It's not your right under the Constitution. I don't understand why people don't understand it. And I've repeated in this episode about 8 times now. So don't let the rhetoric and the emotions fool you. If they do rule in favor of the Mississippi law, then Roe v. Wade, for all intents and purposes, is struck down. Now, what does that mean? Nothing really. It just means the states now get to pass laws how they administer abortions. We live in a mobile society. You look at a map for states that would have very restrictive abortion laws, you just drive 2 hours and go somewhere where you can have one. It's not that big of a deal. So I'll say it one more time for those of you that are on the left or center left. Abortion is not a constitutional right. And if Roe v. Wade is struck down, does not mean abortion is unlawful. Period. Until the next time, goodbye and good luck.